Thank you for joining us for this launch webinar of the Constitution Hill Global Guidelines on Apex Court Appointments. My name is Sujit Choudhry, and I am the co-convener of IFIT's initiative on Apex Court Appointments and your moderator today. I'm pleased to welcome Justice Kate O'Regan, who will speak early on in our panel today. Kate is the founding director of the Bonavero Institute of Human Rights at Oxford University and a former justice of the South African Constitutional Court from 1994 to 2009. She is also a member of the high-level panel that IFIT assembled as part of the initiative on Apex Court Appointments. Kate, we're delighted to have you with us here today, especially as we understand you'll only be able to be here for about the first half of this webinar because of a flight you have to run and catch. Thanks for making the time for us.
Thanks, Sujit. It's a pleasure to be here. Thank you.
Good. And I'm also honored to be joined today by Beatrice Mtetwa. Beatrice worked as a prosecutor in Swaziland and Zimbabwe between 1981 and 1989, and then went into private practice and has been litigating mainly on human rights issues since 1990. She has received many local, regional, and international awards in recognition of her human rights work, and she has also been conferred with honorary doctorates by 5 universities. Beatrice, thank you for being
here. Thank you for making me part of this.
Good. And then finally, we have with us Mark Freeman, who is the founder and executive director of IFIT and the co-convener with me of IFIT's initiative on Apex Court Appointments. So with that framing, let me now first ask Mark to tell us about the origins of the initiative on Apex Court Appointments and the 3-year process that led to the creation of the Constitution Hill Global Guidelines and Apex Court Appointments.
Great. Well, thank you very much, Sujit. And it's wonderful to be here with Kate and with Beatrice to celebrate this milestone of the publication of the Constitution Hill Global Guidelines on Apex Court Appointments, especially since the origins of these guidelines come from Southern Africa. Initially in Zimbabwe, a very seemingly trivial request from a civil servant in Zimbabwe about any examples of score sheets for the appointment of constitutional court judges led us to discover a gap, which you, Sujit, and I developed ultimately together with some of our Zimbabwean and other colleagues at IFIT into what became this very large 3-year process. But the gap that we discovered is the following, which is that there are many important, some cases remarkable, guidelines on the independence of the judiciary and the appointment of judges in a generic sense. The gap is that there is nothing in existence until now. There's been nothing that is tailored to the very unique features and structural characteristics of apex courts. And when we say apex courts, we're talking in particular about the apex or top court on constitutional matters. And we developed these guidelines over a process of 3 years. As you mentioned, we were very honored to have a high-level panel. We had a number of distinguished judges and jurists from Southern Africa who were part of the early work. Along the way, we had support from Yale Law School and other Yale University students, some global law firms, and many people contributed ultimately over 3 years, including over 100 of the preeminent judicial and legal organizations and institutions and networks around the world who gave us incredible feedback on early drafts of these guidelines. And so that was the process. But as I say, the gap really was not to replace what already existed, because as I said, there are many laudable examples of principles and guidelines in a generic sense that relate to the judiciary. But it seemed to us to be a very significant gap to not have something truly tailored and customized to the critical role in a democracy that apex courts play.
Thank you, Mark, for that introduction. I'd like to now turn it over to Kate. And Kate, could you give us your perspective on the guidelines, not just as a member of the panel, but also as a former Constitutional Court judge? And in particular, it would be helpful if you could speak to what stands out for you as particularly important in the guidelines.
Well, thanks, Sujit, and thanks to both you and Mark for inviting me to be here. It's a pleasure to be sharing the panel with Beatrice to discuss what I think is a really important initiative. I think it is striking when one looks around the world to realize how the spread of constitutional democracy has resulted in courts playing significant roles in democratic transitions and in the entrenchment of democracy on all the continents around the world. That has often been accompanied by greater attention to courts, higher profiles for courts, and inevitably questions around the legitimacy of courts in making those decisions. And having very clear procedures and criteria for the appointment of judges to apex courts seems to me to be an absolute central plank of ensuring that constitutional democracy continues to thrive. It is very easy, and we've seen it in the time of democratic backsliding or decay across the world, that one of the first institutions that tends to come under challenge is the judiciary. And it comes under challenge both from the executive, sometimes from the legislature, and sometimes from people in civil society. And it seems to me that it's very important that we build a common set of principles for the appointment of judges, for the procedures around the appointment of judges, and for the conditions of service of judges on these courts, to try to remove from the contestation that happens around senior apex courts questions that relate to criteria for appointment, process for appointment, and to ensure that we get the best candidates into office in these really important institutions.
Thanks, Kate. I appreciate that. So let me just turn it now to Beatrice. And Beatrice, I'd like to ask, please, for you to share your perspective on the guidelines as a human rights lawyer and as a litigator before apex courts in Southern Africa. And we're wondering, from your perspective, what are the important things in the guidelines that stand out for you?
Thank you for that, Sujit. It's very extensive, piece of work. It covers virtually everything we expect. The problem is at a practical level where the assumption is that those who will be using the guidelines and those who will be implementing them are women and men of integrity who will stick to the intention behind the guidelines. Thirdly, we see people coming in as people with integrity, with independence, with all the necessary requirements of people being in those bodies. And sadly, I don't know what happens, certainly in Zimbabwe. Once they are in, they completely flip and change. So generally, we're used to the judiciary being attacked from the outside and being undermined from the outside. But in Zimbabwe, we've seen that the actual capture and undermining is inside the judiciary. And sadly for Zimbabwe, it is spearheaded by the Chief Justice, who, when we draft guidelines like this, we always think will be the biggest defender of the guidelines and everything impeccable about the guidelines. So I don't know if there's a way we could look at how, at a practical level, we could ensure that these guidelines ensure that there's absolutely no involvement from the executive branch of government, because we are seeing more and more judicial players being influenced by political players. You get a Chief Justice agreeing to have a constitution amended to extend his own term. Do you think that Chief Justice is going to change that narrative when the executive wants a presidential term changed in the constitution? So it's the practical aspects that I worry about.
Beatrice, that's a terrific point. And maybe if I could just abuse my position as chair and offer a couple of initial thoughts about what Beatrice's challenge, and then turn it over to Mark and Kate to continue the conversation. I think, Beatrice, I think one of the ways I would respond to your very valid point is to think about the multiple uses and audiences for this set of guidelines. And so, when we originally developed the concept for the guidelines, the thought was that the principal audience would be individuals involved in constitution making processes or institutional reform processes. But there are actually possibly other uses as well. So, for example, it could be that the guidelines serve as a soft law norm for litigation. And as we know, around the world, there's an enormous amount of litigation around judicial appointments, and particularly apex court appointments, through the lens of judicial independence. And this is true in Southern Africa. It's true in South Asia. It's true in Europe. It's been true in Latin America. And so there's a way in which the guidelines can be mobilized by NGOs and constitutional litigators and courts to interpret existing provisions regarding judicial appointments to check concerns like that. I think the other point I would raise as well is that the guidelines have potential to be used as a benchmarking mechanism for international actors, be they funders or foreign states or regional organizations, to monitor and assess the state of the functioning of an apex court in certain countries. And so there are ways in which a different set of voices and perspectives can be brought to bear on domestic developments through international engagement with domestic constitutional processes. So those are my first thoughts, but maybe I'll turn it back over to Mark and Kate. I'm not sure if either one of you wants to jump in.
I'll take the conversation. I'll maybe zoom it back out again to highlight maybe some of the novelties that we have built into these global guidelines. Again, with the benefit of a huge range of judges and lawyers and jurists around the world who contributed to the drafting and editing and review. I think one of the points that I would want to make is a very simple one, and you'll recall, Sujit, it was where we began, which is that when we looked at existing standards in terms of the criteria of eligibility to serve as an apex court judge, we were surprised at the absence of criteria of character. It was very obvious that there ought to be criteria of merit in terms of expertise and experience and so forth, and capacity. But criteria of character were notable in their absence. And so one of the novelties, and you'll see perhaps unusual principles reflected in these global guidelines. You'll see principles such as courage as one of the affirmative criteria that appointing bodies need to look for when it comes to apex court judges, or inventiveness, or independent mindedness. If you think of it like this, if we were just an ordinary company out in the world hiring, we wouldn't only look at merit. We would also be looking into other questions. Character, one way or another, would inform the decision, especially for a senior hire in a company. And yet there's no affirmative obligation, at least based on existing guidelines, to proactively look for certain criteria of character beyond merit. I'll give you another example of something that is novel in the guidelines, which has to do with the fact that these courts, unlike most other courts in any judicial system. They sit in plenary format or they sit in panels. And so having a collegial nature turns out to be very important. Or as appointing bodies, looking for diversity across the members of the apex courts, because this is the face of the judiciary, essentially, before the country. So those are some examples. Others that I might highlight have to do with the procedures. We tried to separate out into three, not necessarily consecutive procedures within the overall appointment process, but we think that each requires its own special set of considerations. So one of those, of course, is an application and or nomination phase. Secondly, an interview and vetting stage. And then finally, a selection phase. And for each of those, I suppose one of the cross-cutting criteria that I'd want to flag for the audience is that whatever the procedures are for the appointment of apex court judges, it is very important, according to the guidelines, that the criteria be made public. That whether it's the criteria of eligibility for the judges, the rules according to which decisions are taken, or even down to the score sheet that is used in the final selection. All of these things need to be have to be public so that everyone in society and any other guardrails of democracy in the country can make reference to explicit standards that are transparent, that are public. So that's another example of something that's very emphatic. And then finally, I suppose I would also mention the final section of the guidelines, which speaks to not criteria of eligibility, not procedures, but rather conditions of service and tenure. And here, especially bearing in mind the many scandals that have become attached to apex courts in a lot of different countries, we include provisions on things like what we call extrajudicial activities and the standard that ought to be expected, in particular of apex court judges, being at the apex, being at the summit of the judicial system, and the special responsibilities they have as apex court judges, not only when they're in office, but also after their tenure as judges. And so we, again, try to provide guidance, all of which, as you said, all three of you, offer benchmarks that can be references for courts, for litigators, for civil society actors, and others.
Kate, did you want to jump in on that or any other point?
Well, I mean, I agree with everything that's been said. And of course, to respond to Beatrice, you can design a system as well as possible, but if people are not going to act in good faith within a system, it's quite difficult to make a system work. But I do think that having clarity on what we expect of the system is, as I think both Mark and Sujit have said, one of the ways to try to hold a system to account. And I think that there are definitely suggestions in these guidelines which may have been discussed in some jurisdictions, may even have been observed as the rule in jurisdictions, but are not often actually formulated in writing and put together as they have been here. So to add to some of the things Mark has mentioned, the idea that these processes should be by and large open processes is something that is not fully accepted across the world, but it is one of the ways in which scrutiny of the process is enabled. So organizations from civil society can watch a process where there are open procedures. Another provision, it also related to procedures, which is important, is the emphasis on fair procedures, that candidates should be subjected to the same level of scrutiny, that there shouldn't be, as it were, what appear to be sweetheart candidates or people who are let off the hook and other people who are subjected to much more searching investigation. So there are elements of the rules here around process, which I think are an aid to accountability in these processes, which is what I think they're aimed at. They're ways of saying to the people who are engaged in judicial appointment processes, you ought to be paying serious attention to the quality of your processes And those of us who are observing that from outside will be able to call if that hasn't happened. It's not a solution to the problem of bad actors, unfortunately, but it certainly provides some of the leverage that is the only way that I think we can move forward, in what can often be very contested processes.
Beatrice, did you want to come back in and offer any thoughts on that point or any other?
There's no question that the guidelines are a useful, reference point. And in our context in Zimbabwe, they are generally what is already there in our Constitution and the Judicial Services Act and the Code of Conduct, etc., etc. The problem is that we have no enforcement mechanism, because when we need to enforce, we have to go back to the very person who's in breach of the constitutional provisions. And it becomes extremely difficult to then go back to say you have not followed the guidelines. We've had a judge who's been disciplined without any due process, and we have argued the matter in the Constitutional Court. And the Constitutional Court itself has said, well, you shouldn't have come here. Yet 6 different courts have said this is a constitutional matter that can only be dealt with by the Constitutional Court. So you have all these double standards where different actors are subjected to different processes, and you know that where you are supposed to get relief is where the problem is. And that's really the major problem that we have. Everyone knows what the right thing to do is. Everyone knows what sort of character a judge in the apex court should have. Everybody knows the criteria, the integrity, the independence, the impartiality. But what do we do when they fail to implement at a practical level like we have in countries such as Zimbabwe, such as Swaziland?
That's an excellent pivot to a question I want to put to Mark, which is, what our plans are to take the guidelines forward and to bring them to life and to implement them in diverse national contexts.
No, great, Sujit, and to pick up on Beatrice's larger point, I mean, I think our sense right now is that it's really important not just to raise awareness of the existence of the guidelines. That's obviously the first step, but to also open up formal dialogue processes across key sectors of the legal profession, the civil service in a country, appointment bodies, judiciary itself. And so the way we're envisaging this is sort of mixed. I would say at one level, we're going to be organizing in a number of countries, in some cases upon request, a set of dialogue processes to bring in the key stakeholders that ought to be in the conversation. And again, it's a combination of raising awareness of the standards that are presented in these guidelines, but then really engaging in serious dialogue around these. We've also received formal requests. It happens that in a number of countries in the world, they're at a moment of judicial reform. This is a high item on several countries' national agendas. And so we've also received requests to actually have an engagement as a kind of review through, depending on what it might be. It could be a Judicial Services Commission, that may be an appointing body. It could be some other set of actors or a court itself. And so in some cases, direct engagement with bodies that have the mandate constitutionally or legally in their country to update the guidelines and norms applicable to the appointment of apex court judges. And then finally, there's a longer term process, which again, I think it relates to this larger point about the problems of practice, or the gap between aspiration and reality on the ground in a lot of places. And I think, Suji, you mentioned it. I mean, the point around litigation is very much in our mind. We think there are many potential users and audiences for these. Again, it can be everything from a bar association to an individual litigator to a civil plaintiff to an NGO to any other body. It could be another branch within the state that wishes to contest, that may have the standing in court to contest. And that's just at the national level. Of course, there's the supranational level as well. So for us, expansive engagements of this sort is what we're looking to. And so for us, in that sense as well, the publication of these guidelines marks really a first step of the next chapter.
So with that comment from Mark, I'd just like to turn it over to Kate again.
Thanks, Sujit. Well, I've been having a sneak preview at the questions that have come up. And there's one in particular, the first one that was put by one of our audience members that I'd like to respond to, which is the good question about whether this looks like finger wagging by the global north at the global south, or the global majority. And I think that would be to misunderstand what the purpose of these guidelines is. The idea is, and you're absolutely right in your question to say that these are live issues, not only in democracies of the South, but in democracies of the North. President Biden, for example, has announced that he intends to ensure that the US Supreme Court adopts a code of conduct, which of course we know that so far it has not. And many of the things that are dealt with in these guidelines are dealt with in ordinary codes of conduct, judicial conduct, in jurisdictions all around the world. So the lessons I think to be drawn from these guidelines are lessons for democracies everywhere. And I don't think the intention by having this conversation, either calling them the Constitutional Hill Guidelines or having this conversation with, by and large, Southern African panelists, myself and Beatrice, is to suggest that these are aimed at Southern Africa. In some ways, I suppose, there are lessons to be drawn from the work done in Southern Africa that are relevant more broadly across the globe. So I understand why you're asking the question, but I do think that these are guidelines that need to be addressed everywhere, and there are lapses everywhere. And in many, there are very few jurisdictions where you could say that all these guidelines are observed in all circumstances. And I think that is why they're very useful. They're an accumulation of insights and experience gained from democracies all over the world.
I was thinking, Kate, that as you know, I'm a Canadian constitutional litigator. And I look at our apex court appointment procedure in Canada relative to this benchmark, and I think we have a lot of work to do. I think it doesn't nearly come close to these standards, and I think the same would be true in the United Kingdom. I think the same would be true in a lot of jurisdictions in the global north. But it's a very helpful reminder, though, I think, as we go forward, to be self-critical and to not focus exclusively on countries in the global south as we take the guidelines forward. So Kate, I know you probably need to leave. So look, thanks so much for squeezing us into your massively busy schedule, and we'll keep you posted as things move forward. Beatrice, do you want to offer anything at this point before I turn it over to Q&A, or should we move to questions?
I'm just going to say goodbye, if I may, just to thank you, Sujit, and thank Mark for all the work that's gone into this, and to say it was great to see you, Beatrice, and great to see a lot of people attending today who I haven't seen in person for a long time. It was a pleasure, and wishing you all well. Thanks very much. Yeah. Bye.
Bye, Kate. Beatrice, do you want to offer any thoughts on these points before I turn it over to Q&A?
Yes, we've had this finger-wagging argument by the global north to the global south. And it's what the politicians use when they don't want to live by the very guidelines they fought for, particularly those of us who are in countries which had brutal wars fighting for basic rights. The simple answer to that is that, like in Zimbabwe, we have a 2013 constitution made by the current government with absolutely no input from outside, and over 90% of the people saying, yes, this is what we want. So it can't be finger wagging by anyone other than the people who said these are the standards we want to live by. And these are guidelines that are in sync with what the people have said they want. It's just trying to avoid dealing with the problem to say we are being finger wagged from outside.
Let me wrap up by thanking Beatrice and Mark and also Kate for sharing your insights today. And thanks to our participants. If you haven't done so already, you can download the guidelines under a link we're sharing in our chat right now. It's also on the IFIT website. And as we've mentioned, the guidelines will now be the subject of a global dissemination, engagement, and uptake process that's beginning this fall. So please stay tuned for further updates, and thank you once again. And we look forward to seeing you at our next event.